Yeah, welcome everyone tonight here at the Max Planck Forum at the Berlin-Brandenburg Academy's Leibniz Hall. This Max Planck Forum is titled How to Protect European Values, Assessing European Responses to Recent Reforms in Poland. The forum tonight is hosted by the communications section of the Max Planck Society's Berlin office. It's a regular format where the society showcases and introduces research that is done in different institutes of the Max Planck Society in different places in Germany into a wider public discourse. And we are very delighted that tonight's forum can be co-hosted by the Max Planck Institute for Comparative Public Law and International Law at Heidelberg. And it's also a cooperation with Verfassungsblock, which is represented tonight by its founder and editor-in-chief, Maximilian Steinbeiß. I'm Alexandra Kämmerer. I'm a senior research fellow and the academic coordinator at the Max Planck Institute at Heidelberg. And I'm also heading our small Berlin office that we opened last year, and that is located just next door at the Wissenschaftsforum at Gendarmenmarkt. Before introducing the speakers and the topic, I would like to thank Susanne Kiewitz, the communications officer here at the Max Planck Society's Berlin office, and also Sabine Schild and Barbara Hufnagel, who have been vital in making this event tonight possible. The topic we will be discussing tonight, the protection of European values in the context of recent reforms in Poland that we have seen since the Polish elections in October of last year, prompts a number of questions that relate to the wider framework of fundamental rights protection in the European constitutional sphere. The question of rule of law protection and the protection of fundamental rights in European constitutional areas has been on the research agenda of the Heidelberg's Max Planck for many years now. The team led by Professor Armin von Bogdandy has been working on these topics recurrently, and I'm very glad that tonight we have also a number of colleagues here in the room who are concerned with these issues under the leadership of Professor von Bogdandy. I would like to welcome, therefore, also Matthias Schmidt and Michael Ioannidis, and then also Paulina Starsky, who has published recently in different fora also on the situation in Poland. We would like to have you all also here on the podium, but we look forward to have you interact in the discussion that we will be having later tonight. The events in Poland shall not be recounted in detail here. We have seen since following the elections in October 2015 a number of legislative changes, most prominently affecting the Polish Constitutional Tribunal and prompting criticism and opposition in the Polish society as well as on the European level and within wider European public spheres. And we have seen also changes with the introduction of the Polish media law, of a new civil service law, and a number of other legislative changes. In December 2015, the Polish government requested the Venice Commission to provide an opinion assessing the constitutional changes in Poland. And in January, on January 13th, the European Commission decided to set in action for the first time ever its rule of law mechanism, and the Commission's results, or the first communication of the European Commission, is to be expected by the end of March. The Venice Commission's report, or the Venice Commission's opinion, has been adopted in the Commission's most recent session on March 11th in Venice. We find here a quite sharp criticism of the recent changes in Poland, and we'll hear about that in more detail in a minute. Preceding the adoption of the Venice Commission's opinion, we have seen a judgment of the Polish Constitutional Tribunal itself that has been issued on March 9th and also prompted the opposition of the Polish government. The government objected to the publication of the judgment, a fact that was also very strongly criticized in quite explicit wording in the Venice Commission in its opinion that has recently published. But we will hear more about this in much more detail by tonight's speakers, and I'm delighted to welcome Professor Dr. Christoph Grabenwarter. Christoph Grabenwarter is a judge at the Austrian Constitutional Court, a professor of public and international law at the Vienna University of Economics and Business, and also the vice president of the Council of Europe's Venice Commission. And for full disclosure, I should also mention that he's a member of the Academic Advisory Board of the Max Planck Institute for Comparative Public Law and International Law. I'm also happy to welcome Renata Uitz, a professor of comparative constitutional law at Central European University in Budapest, a sophisticated comparative constitutionalist, but also critical observer of recent developments that we have seen in Hungary in these last years. I would like to welcome also very warmly Dr. Adam Bodnar, the Polish Commissioner for Human Rights, who was sworn into office on 9th September by the Polish Parliament, the same. Before taking up this office, he has been the Vice President of the Helsinki Foundation for Human Rights and a person with a very strong profile in the NGO section engaged with protection of human rights. Last but not least, I would like to introduce Professor Dr. Armin von Bogdandy, the director at the Max Planck Institute for Comparative Public Law and International Law at Heidelberg. Armin von Bogdandy is also professor of public law at Goethe University in Frankfurt. I would like to invite the speakers to a short statement here on the panel, and I would like to invite Christoph Grabenwarter to open this first round by providing us with some background on the Venice Commission's opinion. He has been rapporteur in the drafting process of this opinion and also been part of the mission of the Venice Commission, which visited Poland in early February and met with representatives of the parliament, but also of the NGO and different branches of government.
Thank you, and thank you also for the invitation to this forum tonight. It couldn't have been planned at a better date than tonight, because I just returned from Venice on Saturday night, and I had the opportunity to get fresh clothing before coming here. So everything fine. We're really at the point to have all the information on the table. I will not be too long, because this shall not be a discussion on the Venice Commission. It is a discussion on Poland. So what should be given as background information should be the absolute minimum. As has been pointed out by the moderator, Alexander Kämmerer, the opinion has been produced by a team of rapporteurs. That's the usual procedure. What is not usual is the number of rapporteurs. If you look at the front page of the opinion, you can see that there are not less than 6 rapporteurs. Which is not usual is also that one of the rapporteurs is a lawyer from Columbia University, Sarah Cleveland. The United States have been a member of the Venice Commission for a few years now. And the rapporteurs come from all over Europe. This is always a policy not to have members that are too close to the situation, but still one tries to have lawyers that are familiar with the problem, and so as it is an issue on constitutional justice, it was clear that one of the rapporteurs should work in the field, should work either as academic or even as a judge, him or herself. So this is one factor, and one factor which gives particular weight to the opinion, because the request, as has been said, has been made by the foreign minister of Poland. And of course, in the discussion, there was the question, how would we deal with the problems? Initial remark that has to be made at the outset is, what is the opinion exactly about? The issue of an opinion is always determined by the question. And the question came from the government, and it was on the amendments of the legislation of 22nd of December. And that means legislation on a number of procedural things. Most of you are familiar with that, either from personal interest, from personal research, or from the media. If you want to describe all the changes, and we will have the opportunity to go into details, they all deal with the decision-making process, and government says it is aimed at making procedure more effective, speeding up the procedure, making it more transparent. That is the government position. And if you look at the changes, you can see that it also makes decision-making more difficult. You have a 2/3 majority requirement, you have a sequence rule, not for all proceedings, but for the proceedings in abstract norm control proceedings. You have certain rules for the delay that the hearing can be dated, so you have to do it 3 or 6 months beforehand, which does not give the possibility to decide right away. So that is about the characteristics of these changes. They make it more difficult to come to a decision. And you cannot isolate this legislation, and the Venice Commission indeed has not done so, although there was a discussion with the government whether it was legitimate or not. It cannot be separated from the crisis that emerged with the election of the judges. And here one has to say, and I say it also publicly, what is in the report. The problem started before the current majority took over in government. It started with the legislation, I think it was 25th of June, where the old majority has, let me say, changed the legislation in favor of electing some judges prematurely. I do not want to go into more detail. And the reaction was a sort of, let me put it, overreaction in November to vote for 5 judges. And the Constitutional Court on 3rd of December has made a decision that 3 of the judges were legitimately elected by the old majority and 2 by the new. And as the events in the beginning of December made things even more difficult by voting another set of 5 judges, we have now the situation that we have 18 judges for 15 posts. Either side says 3 of them are not legitimate. At least 2 judges of the newly elected are now accepted also by the Constitutional Court, and they also, which is an important thing I want to stress here, they took part in the decision. Unlike the government did not appear in this K47 proceedings, but these 2 judges nominated by the new government, dissenting but taking part. This is an important step, and this step should be kept in mind when we discuss this. So I do not want to be too long, but I want to highlight one thing at the beginning about the working methods of the Venice Commission. The Venice Commission is not a court, and it's not simply a round of discussion of academics. It's something in between. It has the policy and the procedure of looking at things closely. Therefore, you have nearly always a visit to the country concerned. We met on 8th and 9th February a number of government and judicial representatives, including the Ombudsman, but also the Supreme Court, the Constitutional Court and various ministers. Against the background of this visit, the rapporteurs have prepared their provisional comments, and they were put together in a consolidated version of a draft interim draft opinion, and this draft opinion was sent out to the members, and it was after we received quite late, I would say, we received comments from government. This is also a usual procedure. Usually the Venice Commission gets these comments a bit earlier. Here was the special case that it became public that the Constitutional Court, the Constitutional Tribunal, will deliver its decision only 2 days before the beginning of the session, and government said from the outset they would not present their comments on the draft opinion before the Constitutional Court has made public its decision. So we have this situation now. The final decision that has been, the final opinion that has been adopted has been changed in one point, and that would be already my final remark for the first round. The last 2 paragraphs comment on the decision of the Constitutional Court, which is, by the way, quite similar in its results. I do not know the detailed reasoning already because I do not have a full translation into English. But the Venice Commission, in very harsh and clear words, says it is a duty under the rule of law in Europe to respect decisions of constitutional courts and also to make these judgments public. This is the last paragraph of the final opinion, and I think, and it says, the last 2 lines say that publishing and respecting this decision is a precondition for further discussion, for compromise. Whether this is a politically correct statement, we do not know, because the Venice Commission is a legal body and a body of legal experts, but from a legal point of view, there can be no discussion that respecting a Constitutional Court decisions, whether there are discussion on the procedure or not, is another thing. Perhaps I might make a footnote here. What is the reason why government is hesitating to publish this opinion? Because it says that the proceedings were not legal. And here, again, the Venice Commission is quite clear, and it has not said so for the first time. The Venice Commission, and it has commented, I read it, I think the person is in the room, it was already commented, discussed in the Verfassungsblog. It is a theoretically interesting question. What is the legal basis of a constitutional court which has to decide on its own rules of procedure, which could make it ineffective? I do not want to go into detail. The Venice Commission had says already on 2 occasions. One occasion was concerned Romania, another one was Albania in 2006 and 2009 respectively, has said that in such a case it is legitimate, it is according to the rule of law, that the Constitutional Court decides on the basis of its former rules of procedures, not the rules of procedures that make the court, that hinder the court, in fact, to fulfill its function. There can be a lot of theoretical argument on that, and it is not an easy discussion, but I think it is important to say that in this case, the Venice Commission was quite clear and shared the opinion of the Constitutional Court, who in an interim decision has already made public this view. I think it was on the 13th or 14th of January in an interim decision. So this would be my first comments for, and I hope this is a basis for the further discussion. Thank you.
Thank you. So I would like to give immediately the word to Adam Bodnar to provide us with a Polish perspective on both the legislative changes which we have seen, but also the Polish reactions on the recently published opinion of the Venice Commission.
Thank you very much for inviting me here. I'm not sure whether I can present the Polish perspective. I think I can present my own perspective as the Polish ombudsman on this issue. And I would like to start with saying that on the one hand, I'm honored to be invited here, but on the other hand, I'm ashamed that Poland is a part of this story which was part of the Hungarian experience last years. I remember when we discussed all different problems with Professor Uitz a couple of years ago. I didn't expect that Poland will be in the same situation, that any international control procedures will be started, that we'll have a situation when there will be an attempt on the rule of law, independence of the institutions, and democratic values in Poland. And I would like to underline that in Poland we are, I would say, legal society, and a lot of opinion makers. We are very proud of our checks and balances institutions. We are very proud of the Constitutional Court, which has already 30 years of history. We are very proud of my institution, Ombudsman, which became a pattern for other Central European countries to copy and to build a strong ombudsperson's institutions with a lot of significant powers. And basically what we observe last month is an attempt to paralyze the Constitutional Court. And in fact, this attempt is, until now, in my opinion, successful. It is true that Venice Commission has produced the opinion. There is a lot of discussion before publication of the opinion, when the delegation of the Venice Commission was in Poland, but also after the publication of it. But you should know, and it was mentioned already, that the publication of the opinion goes almost in the same time as the publication or issuing of the verdict of the Constitutional Court. This judgment of the Constitutional Court by Law and Justice government is diagnosed, or is named, that it is not a judgment, but it is just a communication, it is just a statement which was made by 12 judges of the Constitutional Court, but it does not have a value of a judgment. While others are saying that the Constitutional Court was perfectly equipped to give a judgment in this case, even in a situation when the composition of the court was not in accordance with this new law that was subject of review by the Constitutional Court. Because under this new law, the Constitutional Court should adjudicate in the panel of at least 13 judges, while there were 12 judges adjudicating. So it is this a situation of I would say, of a vicious circle. Whether the Constitutional Court could make a judgment on an issue which was in fact aimed to paralyze the Constitutional Court itself. And the Venice Commission, in my opinion, is very important because it says, yes, it could. And second, yes, the judgment should now be published. It was a judgment, it was not any communication whatsoever. So one part of the follow-up, I would say, to the judgment and to the Venice Commission is right now the discussion in Poland whether the government should at all publish the judgment. So the government right now presents a point that because it was not a judgment, because it was, in the opinion of the government, communication or a statement of judges, the government cannot publish it in the official journal. And if you cannot publish, if you will not publish it in the official journal, then this judgment, in fact, will create something like a legal chaos. I don't want to go into details what would be the consequence for courts, what would be the consequence for the Constitutional Court or for the administration of non-publishing this judgment, but basically it will produce dramatic results from the point of view of rule of law. But I think we can treat this issue from the, I would say, institutional point of view, from the point of view of some discussions concerning the Constitutional Court for blaming the previous parliamentary majority for appointing too many judges in advance to the Constitutional Court. But in my opinion, the most important part of this whole story are the consequences of this whole situation. Because here in Germany, you perfectly know what is the value of the German Verfassungsgericht for the adjudication, for the regulation of the daily life of citizens, for the stabilization of the of rights and freedoms, and the whole legal system. And in Poland, in last months, we have the parliament has adopted a number of laws that create, I would say, centralization of the power in the hands of the government. Most importantly, one of those laws that were adopted was the new law on public media. The law that provided that the management boards and supervisory boards of publicly owned media, like public television, public radio, are and appointments of persons to management boards and supervisory boards are right now not in the hands of the national constitutional organ, which is the Broadcasting Council, but in the hands of the Minister of State Treasury. And the result of this was exchange of boards of those public media, but also it had quite dramatic consequences for a number of journalists that were working or are still working in public media. Just to note, non-governmental organizations, a coalition of them, has submitted recently a request to Council of Europe Secretary General Mr. Jagland to start another Venice Commission monitoring mission concerning public media law. Another law is the law on civil service, which aimed towards dismissing all the civil servants at the level of heads of departments or deputy heads of departments. Altogether, 2,000 persons. And basically, those persons who were dismissed could be proposed a new job, but not necessarily. So the question was to what extent the new government trusts them as regards their qualifications and their loyalty. And some good people who were non-political professional civil servants for years have lost their jobs. There is also a new law creating additional surveillance powers concerning use of internet data. I will not go into details, it is quite a complex discussion, but it created some additional possibilities of monitoring activities of citizens in the net. There are also some other laws in the pipeline. Like, for example, there is one law which concerns the ombudsman institution, as well as president of the Supreme Chamber of Control and the Ombudsman for Children. It is the law regulating the procedure for deprivation of immunity. Obviously, this law does not produce any immediate effect, but it was challenged. The idea of this law was challenged by the Office for the Security and Cooperation in Europe with the official opinion, but basically there is no reaction to this opinion. And of course, in the discussion, there are some other laws, like, for example, reform of the judiciary. So having said this, I would like to say that the situation when the Constitutional Court is paralyzed means that the court cannot adjudicate on all those cases that were pending before adoption of this law on 22nd December, but it does not have still power of adjudicating on all those new laws. And for example, this new surveillance law, new law on police, will be subject of monitoring of the Venice Commission. So Venice Commission has announced today that it will deliver the opinion on 10 and 11th June this year. But still, I would say that some things are happening now. Some changes are adopted now, and this whole international machinery is working, and the machinery of the Constitutional Court is working, but we witness some specific changes that are happening in Poland that aim towards centralization of state power. I would like to underline that when we had this case before the Constitutional Court, it was not like that there was one single abstract motion by some opposition group challenging this. There is a strong opposition against such changes in law and in the rule of law framework of, I would say, all the leading legal figures. This law was challenged by the President of the Supreme Court, it was challenged by the Ombudsman, it was challenged by the National Council of Judiciary, by three opposition parties, and there were also 4 amicus curiae organizations that provided their opinions. Bar Association, Association of Legal Advisors, and two independent NGOs. So I would say that you can observe the unification of approach among the legal profession, among legal circles towards this. Obviously, there are some law professors, some individuals who are saying that everything is okay and we shouldn't worry so much. But I would say all those marches on streets of Warsaw, as well as the current protest in front of the Chancellor of the Prime Minister, requesting the government to publish the verdict finally, are the sign that, to be honest, Poland is very much divided as regards this issue. I think that as of now, the most important issue is to publish the judgment of the Constitutional Court, because a situation when the government is challenging the verdict by refusing to publish it, by using the technical activity, which is the publication, as a way of controlling the quality and the content of the judgment, is something, I would say, unprecedented as regards rule of law framework and constitutional justice framework.
Okay, thank you. I would like to give the word and the floor to Renata Uitz for a perspective from Hungary.
Well, thank you very much, Alexandra, and thank you very much for this kind invitation. I definitely don't want to enter some sort of a championship of horribles and try to compete with Poland. Suffice it to say that Hungary's contribution to the EU's pre-Article 7 monitoring mechanism is now going to be further strengthened by Poland, it seems. So what comes is 7 comments which are partly some observations on what to expect on the pre-Article 7 monitoring mechanism, which was chosen by the Commission, and partly drawing on or reflecting on other European mechanisms which were trying to put unwilling constitutional actors back within, or at least in sync with European minimum standards of constitutionalism. The first feature, which is in clear emphasis in the article in the Commission's proposal, is that it's meant as an early warning mechanism which will weed out systemic threats to the rule of law. Now, it's a good question what a systemic threat is and how many individual steps do you need in which zones of constitutional operations for a threat to become systemic, and in what form do they need to be? Do they need to be in legal form? And once they are constitutionalized, what is the real basis to challenge them? Now, there is no earlier mechanism than the Venice Commission, and the Polish critiques of the government learned it very early, when they were trying to warn the Venice Commission of developments that cooperation means that the government needs to initiate the procedure. So dissident voices, opposition voices, and criticism are channeled within these European mechanisms once the government is willing to play. So this cooperation component, while it's clearly explained by foundational principles of both the Council of Europe and the EU, puts a very important limit on how criticism and dissent can be expressed from domestic players and also other players against the measures taken by governments, even when they are self-proclaimedly illiberal and departing from European principles. Now, the second question is that although there is an emphasis on dialogue and cooperation, I guess we still need to think a little bit about what's the point of dialogue and cooperation. From the Hungarian case, it's very, very clear that the government in most instances was clearly aware that it's acting in violation of European minimum standards. So the aim of the dialogue was hardly to make it clear what the applicable minimum standard was. Now, if the aim of the dialogue is to keep people at the table, then it seems that these extended multi-stage procedures actually create an opportunity for governments to cultivate a spirit of defiance in the form of a sham of a dialogue. The real peril is that the more generic or diplomatic the language of an opinion is, the more likely that a government, which is otherwise not friends with European standards, will mock them domestically or turn them around. I have to say that the Venice Commission clearly was learning, and the learning curve was very steep with Hungary. And you can see in the language of the opinions how they are becoming more and more clear and less apologetic. So I was really smiling when I heard that the Poland opinion uses a very, very clear and non-compromising language. Now, the third point is about long cooperation procedures, is that the timing is very crucial in these processes, and governments which are unwilling to comply with minimum standards actually play with or strategize with the delay which is built into these procedures. Essentially what we see is the immediate political gain today or tomorrow, for which the price will be paid, whether in money or in politics, many years down the line, maybe by a successor government. What happens if, for instance, due to their arrogance, like in the Hungarian case, the national legislator doesn't include the domestic remedy? Thus, there is a relatively direct route to the European Court of Human Rights, or maybe an infringement procedure turns to the point where the Court of Justice finds Hungary in violation. The judgments are in a technical language. They are maybe 2 or 3 years from the initial constitutional controversy, and they only matter domestically if there is a translator who is willing to re-thematize these very technical judgments into constitutional terms to explain why the violation of a directive on data protection matters for the quality of democracy in Hungary. These players are either political opposition parties who are not in a robust position, or civil society organizations which are under threat anyway for their very existence in a highly controlled media space. The fourth point, which is important to emphasize about all of the European mechanisms, is that ultimately when we talk about governments which are very keen on silencing dissent domestically, the European procedures and reliance on them create a situation where patriots defend the government at home and dissidents turn to Europe. So they essentially enable less than democratic governments to pitch Europeanness and dissidence towards patriotism and national values, in a way generating parallel discourses on European constitutionalism and national constitutional discourses. So instead of having a multi-layered European constitutional space, you have parallel universes, and these governments are very proud of promoting their own Sonderweg. Now, the fifth point is that which is very important to keep in mind, especially when looking at the EU procedure, is that the EU and the national political spheres work according to biorhythms which are absolutely out of sync. the Polish or the Hungarian saga matters as long as there is no other genuine EU constitutional or economic crisis. When there is the Euro crisis, when there is the migrant or the refugee crisis, then these are secondary stories. And in the case of Hungary, even when the EU has its own institutional priorities, such as the campaigns of the new commissioners, national constitutional concerns all of a sudden vanish. They don't become secondary, they vanish from the European constitutional discourse. Now, point number 6 is that, and this also goes mostly to the EU framework, within the EU, the political, the economic, and the legal discourses and their consequences are absolutely unrelated to each other. Illiberal governments or just uncooperative, less than democratic governments learn it very quickly that whatever they do in terms of legal compliance does not affect their voice and wisdom and resonance in the political sphere, and these two absolutely have nothing to do with how much EU funding is going to be available for their pet project. As a result, violating basic constitutional or legal premises, as long as it doesn't result in freezing of funds, pretty much is a game without consequences. Now, the last point is the 7th, is how a European monitoring or control mechanism or feedback mechanism is an extremely good terrain for these governments to pitch a discourse of national constitutional identity against European constitutional identity. Talking to a German audience, you would be really surprised to see what national constitutional identity might mean to a government in these countries and how different it is from what the German Constitutional Court understands by it. It's the responsibility of academics, of civil society organizations, in principle of government, and also European monitoring actors and procedures to be able to tell apart the bluff of national constitutional identity from the genuine claim. And the Venice Commission made a very important point in an early Hungary opinion, where they were willing to call this bluff the government was making in the form of comparative constitutional law arguments. And I'm urging the Commission and praising the Commission for being able to say that the national constitutional identity arguments made by the Hungarian government are going against the European minimum standard and as such cannot be taken seriously.
Thank you very much. I would like to give the floor now to Armin von Bogdandy for some even deeper insights into the multi-layered European framework.
Yeah, good evening, everybody. Thank you for coming, being part of the organization that organizes it. I'm very happy that so many have come, and I hope it's interesting to you. I want to make 3 core points. One is this our business? To look into what's going on in Poland. The second will be, what are the most important instruments at hand? And the third one will be how to deploy those instruments. That will be my 3 points I want to make. Now, the first one is this our business? And that is an important question, because those of you who have seen the Polish Prime Minister speaking in the European Parliament, she had 2 core points. One is sovereignty. Poland is a sovereign country. And the second one is we are fulfilling a popular mandate. We have a very strong democratic legitimacy, so go away. That is her argument. And it's a strong argument that we have to take seriously. So the question is this our business? Now, the our, it is not so clear because, of course, we might look at that as being German citizens or Austrian citizens or Hungarian citizens. But we are more than that. We are also European citizens. We are in a common European enterprise. And we are even in a bigger enterprise, which is the enterprise of the democracy through law, of the Venice Commission, where also the United States is participating. So if we are interested in what is going on in Poland, it is not just by our national identity, but it is because we are together by constitutional decisions in a bigger enterprise. That's the first important point. But nevertheless, the question sticks. sovereignty and democratic mandate. So we need strong reasons why we think that a government just elected implementing its platform, why we go against it. And to me, there are two core arguments, a normative argument and a functional argument. The normative argument is, in what kind of community are we living together? So it is said, both for the Council of Europe and even more so for the European Union, that that is a democratic community. Now the question is, what does that imply? Does it imply what Polish people now call a nomenclatura, demokratura? That's to say that really the government stands at the core and that the rest is not important, as some people of the Polish government has said? Or is it a constitutional democracy? That is a core question. And in my understanding, constitutional democracy is the very basis by which we are together. And if that is touched, it's our business to deal with it. That's the strong normative reason. But then there's also a strong functional reason. And that is the rule of law thing. If we are together in the European Union, we recognize a lot of decisions. And we are together on the presumption that the public institutions in those other countries are law-abiding. That's the very presumption of being together. And if a government states that it does not respect the decisions of its constitutional court or its constitutional tribunal, that is really the incarnation of not respecting the rule of law. And for these two reasons, a normative reason and a functional reason, I think it is our business. So I think we can confront the Polish Prime Minister by saying, yes, you are a sovereign country, and yes, we respect democracy, and yes, we respect that you are implementing your platform, but there are things that you cannot touch while being part of this. I think we have two strong grounds. Now, next point, what are the instruments? There are quite a number of instruments. There's no reason to feel very weak. So there are the instruments of the Council of Europe. There's Council of Europe giving an opinion on the request of the country. That's a very strong instrument, and the Venice Commission has just delivered. Then there's also the possibility, and that is now being put into place with respect to the police law, that the Venice Commission gives an opinion on the request of the Council of Europe. Now, that's a little bit different when it comes to the legitimacy, but nevertheless, that's a strong argument. Then the third argument that we have is the rule of law framework that has been set up by the Commission and that now is deployed for the first time with respect to Poland. For that reason, it is very important, because if it is put on the right track now, we have an important instrument. Now, the Council says that this is illegal, that the Commission has no business in that. I think we can refute that, because if we see that the role that the Commission has under Article 7, it can be argued very, very well that this is a legal instrument now that it is deployed, and it brings an important step in that procedure, which is that without going down the full confrontation, you have some form of intermediate negotiations by which you can move the government into a good direction. But you need, in order that to work, you need the last instrument, and that is the Article 7 procedure, by which you can the Union can decide that rights are curtailed of the country. Now, there a lot of things went wrong, and a lot of political mistakes has been made. First of all, by the former president of the European Commission, who called that the nuclear option. What a stupid move. If you have an instrument and you call it the nuclear option, you cannot use the nuclear option. Never, ever, being a responsible politician. So either he is stupid or he wanted to destroy that instrument. It's not a nuclear option. It is what you have in most institutions, that if you are not abide by the rules, you cannot, forfeit some of the rights in it. So it's not a nuclear instrument. It's a very meaningful political instrument that has to be used with intelligence. Moreover, in the media, there are a lot of people who have no idea of what is written in the treaty, although they are lawyers. They say you need unanimity to use this instrument. That is not true. You need 22 member states to deploy it. So even Hungary is not in a position to make an obstacle to use this instrument. It's a huge number, 22 member states, but it's a feasible thing. And even the Hungarian government is not so much in line with the Polish government in that respect. So it is a feasible instrument, and I think that is something which is very important to bring across to politicians, that it is not a nuclear option, but it is a meaningful political instrument that you need in your backhand, not to deploy it right away, but you need it in your backhand. And second, that you can deploy it. So you have these three instruments. Now, how to deploy them? The most important thing is to deploy them in sync. That's to say, when you have, and that's why we are now in a good position, because we have the opinion of the Venice Commission that has been requested by the Polish government. Now, in my understanding, all the other institutions should stand behind it. The European Commission and the European Union should say, we are not telling you, we, European Union, or Germany, or France, or whatever, we are not telling you what to do. What we are telling you is to obey the opinion that you self have requested. So stand behind it, but stand behind it strongly. That can make a difference, and that it can make a difference, and that's my last note, we see that from the accession procedure. When those countries were preparing to be part of the European Union in the 1990s and the early 2000s, that was the game. That's to say, the substantive standards were devised by the Council of Europe and the Venice Commission. They told the countries how they should reform in order to be part of the club, and that was a communicative thing. It was not hierarchical. You could not say this is Germany or France or so imposing itself. It was a much more communicative setting. And the European Union said, if you do that, you become a member. It's Article 49, it's the membership perspective that put the compliance pull to these norms. Now, the compliance pull of becoming a member, we don't have that anymore, but now we have Article 7, and that is why Article 7 is so important. Perhaps not to be deployed at the end, but it needs to be a serious thing as membership at the moment when those countries wanted to be a member. So that are my three questions and how I think they should be responded. Thank you.
Thank you. So we have now really a very complex tableau bringing to our view the multi-layered interrelations between member states, between the EU level, between the Council of Europe level, and it prompts the question, inter alia, whether a dialogical and non-agonistic discourse, as the European Commission requires it in its rule of law mechanism, is at all possible in such circumstances and in such a kind of splitted constitutional landscape that we see here. Also, we see the riddle of constitutionalism opened up, the question how democratic self-determination and fundamental rights and sovereignty and rule of law interrelate. And apparently, on the national levels, there are very different views also opposed to the kind of common trans-European sense that Armin von Bogdandy has outlined in his presentation. And I would like to ask the speakers on the panel for a short reaction on each other's interventions before we then open up to the public here, but also to our virtual public that is following the live stream we are having via Verfassungsblog tonight. May I ask you to start?
Yes, thank you. So there are so many things to say and to agree with that I will not do that, but I will follow the example of Armin von Bogdandy and just raise three things. First of all, Renate Uitz has mentioned a very important point, that is the point of timing. We see an incredible speed going on since November, December. And one of the strengths of the Venice Commission is also speed. It has been mentioned by Georg Nolte in a seminar we had in Budapest at the occasion of the changes. It is really the strength to have an opinion within a few weeks, because it would not make sense to have an opinion in September with 2,000 footnotes. It would be too late. That is one thing. Second thing, I'm convinced that, and it refers to the first point Armin von Bogdandy has made. It is not a question of democracy or rule of law. It is a misunderstanding of, and perhaps it's a deliberate misunderstanding to say we are democratically legitimized by a majority. So we have also the legitimacy to change constitutional things that are subject to a two-thirds majority in parliament. And there's no and that's a big difference to Hungary. There's no two-thirds majority in Poland. And I think it's not only a phenomenon in Poland, it's a phenomenon throughout Europe, and it's not only a phenomenon of Central and Eastern Europe. You get this feeling that one does not think of a constitutional tradition, a constitutional, let me put it, a conscience of constitution, which goes back to the 1920s, in fact, and the German-speaking discussion on the guardian of the Constitution. The guardian of the Constitution is not at the disposal of a simple majority in Parliament. This has to be said at the occasion of this discussion. My last remark: the European discourse is very important. It is important to put pressure on both sides, government and opposition in Poland. But I'm convinced, after having had many discussions with all the stakeholders in Poland, that in the end the solution can only be found in Poland by a civil society, by political forces, by the media, who are still in a good shape, I would say. We have a vivid discussion, we have a lively civil society, and I think all forces have to aim at a compromise, which cannot be, a legal argument can be a one or nothing game, but a political process must look at finding compromise solutions. And I think the first thing to solve is how to make 15 out of 18. It's a mathematical question which is easy. You deduct 3, but it's difficult if you have judges in place and not so many seats in a court. Thank you.
Thank you. Renata?
So maybe three quick points. And the first one is that this debate is about who is the guardian of the Constitution and who can reach the guardian. And in this respect, it's interesting to see that both in Hungary and in Poland, the constitutional courts became very early a primary target, and the method is different. Hungary had constitution-making majority, Poland did not. But in terms of trying to pack the court, trying to make it difficult for the court to decide, and trying to make access to the court difficult. So the logic of the measures is very similar. The question now is, how does it affect the local guardians in the other member states in the long run, when some of these constitutional tasks are exported to European constitutional actors, and there is a multitude of them in different procedures, in different capacities. The second point is really, what is the constitution in all the member states exactly? And this is about the incorporation of European constitutional values to member state constitutions. After all, accession processes were about partly incorporating some of the constitutional acquis. Now, here I have to say that that especially the Court of Justice is making this discussion extremely difficult, because it's already tricky that the EU language is the language of the rule of law. So while the domestic discourses are constitutionalist discourses, the EU language, because of the treaties language, is that of the rule of law. By the time the infringement cases hit the Court of Justice, the Court of Justice starts to talk about violations of secondary legislation. The Court of Justice could have used in the Hungarian case the Charter. It did not. Nobody really knows why the Court of Justice in all other contexts is so unhappy about the Charter, but there will need to be an agreement from the EU, not so much from the Venice Commission, not so much from the ECHR, but from EU actors, to be able to settle on how the rule of law language is a constitutional language and is not simply the language of secondary legislation, with the caveat that, of course, member states participate in making secondary legislation. And the third point is in reflection to what Dr. Bodnar was saying, that we very often focus on formal rules and how formal rules comply or do not comply. But half of the story is in what is in addition to formal rules, the hidden threats, the threat to particular constitutional office holders that they might be held criminally liable for crimes they may have not even dreamt they committed, the 9-year terms of appointment in Hungary, the immediate removability of civil servants. Sometimes, and it's extremely difficult to bring these contextual components into discussions when we are talking about 3 or 4 amendments to a constitutional tribunal law, but you will never get the full picture without the hidden threats that make up the daily atmosphere of these constitutional changes in the member states.
Thank you. Adam Bodnar?
Okay. Just maybe also I will try to make 3 comments. First, I really like what Professor Bogdandy said about this constitutional democracy. It was basically part of my speech during the hearing before the Constitutional Court, that the whole thing is not about having a democracy where the parliamentary majority rules in an unrestricted way, but it is about having constitutional democracy, which means that you have a power to rule the country, but still you have to obey certain constitutional rules, because it is important from the point of view of guaranteeing certain principles that are set in the Constitution, as well as rights and freedoms. And I would like to quote here one gentleman. His name is Professor Karol Modzelewski. He was a Polish dissident, one of those persons affiliated with Jacek Kuroń, with Adam Michnik. Altogether, he spent 8 years in prison during communist times. And Karol Modzelewski said such a thing, that he is against all those changes concerning the Constitutional Court, concerning public media, concerning all those rules aiming towards concentration of power. But at the same time, he does not have any problem. He's even supporting social programs proposed by the government, additional tax law, additional tax on supermarkets and hypermarkets, additional 500 zlotys per each child. So basically, he indicated quite clearly that you can really rule the country and implement your program without changing the institutional setup of the country. But unfortunately, this whole game about the Constitutional Court is about changing rules of the game and changing the constitution without making a formal change of the constitution, because there is no parliamentary majority to make it. And in this context, there was one significant problem in this whole debate concerning Constitutional Court in Poland, because constitutional justice as such in Poland, to a great extent, is an abstract idea. Majority of people do not really understand what does it mean to have a guardian of a constitution, to have the independent court that is responsible for regulating and balancing all those rights and freedoms and public interests. And at the same time, if you ask anybody, you will always find some arguments why you dislike the Constitutional Court. Because, you know, it didn't make a favorable judgment concerning reproductive rights, because it didn't protect pension funds properly, because it didn't regulate properly relation between the state and the church or religious organizations. So you can always find arguments why you dislike the Constitutional Code. So it was very difficult in this early period to present an argument that it is really important for the general public to have a Constitutional Code as a guardian, because some people translated activities of the Constitutional Code by looking at particular judgment, not at the abstract idea of controlling and making checks and balances on the legislator, but looking at the abstract idea. As a final note, I would like to say that, and it refers also to Professor von Bogda, the statement on this European citizenship and this European constitutional space. Because sometimes this whole discussion is presented in Poland that we are something like a lonely island in this sea of the European Union. But in fact, there are more and more interactions between rule of law framework of Poland and other countries, such rules like mutual recognition of judgments, which implies having independent courts and impartial judges. But also this particular situation of the Constitutional Code is quite interesting, that the court itself has asked the preliminary reference to the Court of Justice of the European Union. In one case, which was in fact initiated by my predecessor, Professor Elena Lipowicz, it was about VAT tax on e-books. So this case is pending before the Court of Justice of the European Union. But it shows something interesting, that the Constitutional Code is a part of the bigger European infrastructure of constitutional justice. And because it is part of it, it should be independent.
Thank you.
Yeah, so I would like to add quickly 3 elements. One is on the possible instruments. And I think it is important to see that under Article 7, it is not just voting rights, it's also funding. So the funding that goes to Poland is also under Article 7, and it can be curtailed at the moment that the Article 7 procedure has been applied. That's the first thing. The second thing I wanted to underline is the difference between Hungary and Poland. And that's a very important one. In Hungary, the government has not reached the formal rule of law. So the legislative procedure and the procedures to amend the constitution have been obeyed. That is different now in the Polish case. The formal rule of law is not obeyed, and that makes a very important difference, and that gives also a much more strength to the European response. And for that reason also, however, and that's my last point, that is why I am so hopeful that it will be the Poles themselves to put that right. Because constitutionalism and the rule of law is so deeply imbued in the Polish identity. And just to make you 2 points, in the more than 100 years that Poland did not exist, the constitution of the First Republic, the constitution from 1797? 91, has been taught throughout the entire time as if it were the Polish constitution. It was, together with the Polish church, the moment of identity by which the Polish nation was formed. And then, in the Second World War, in the German prison camps and in the German concentration camps, the Polish taught administrative law to the people in the prison camps. It was so important to them that even in that situation of utmost despair, they thought they need to teach administrative law, the law that controlled the executive, to maintain what they thought was important. So I think it is so deeply within the Polish identity and the Polish people that at the end, with some help from your friends, things will go right.
We would like to open up now, and I would ask Max Steinbeiß whether we have some reactions or comments from outside.
Yes, we do have some reactions, in fact. There's one question which I will just read from an email on behalf of Rüdiger Holzbrinken. Good evening. First of all, I wanted to thank you all for the interesting discussion. I have a question to all participants. In Germany, we grant the president a right to check formal aspects of a law before signing it. Shouldn't such a right be imminent also in Poland for the highest representatives? Otherwise, the president or the prime minister are just bound instruments. I ask this because one of the decisions of the Constitutional Court in Poland is invalid, either the one from December 2015 or the one from March 2016 has a defect. The decision from December 2015 was published by the government. In December, the court decided about its own procedure, law from June 2015, by applying this new procedure itself. Now, the court again decided about its own procedure, law from December 2015, by not applying the new procedure. These differences in applying procedure should have some impact, in particular against the background of the fact that the Constitutional Court could have decided already by 18th of March 2016. Sorry, 18th of March 2016 by applying the new procedure. So this is one question, and then other input from the online audience comes from Professor Laurent Pech of Middlesex University, who has a remark to Armin von Bogdandi's point that there is no unanimity required, and he adds to this that this is in fact correct with respect to Article 7.1 of the treaty, which requires a 4/5 majority, but unanimity is required under Article 7.2 before sanctions can be adopted by the Commission. Thank you.
Okay, thank you. Would you like to respond to the first question and then?
I think this question concerning preventive control is a very interesting question because, in fact, under the Polish Constitution, we have a right of asking for preventive control. And in my opinion, it would solve a lot of discussions and problems. The only institution that is empowered to ask for preventive control of the law is President of the Republic of Poland. So President has a choice before signing the law. Either he signs or he vetoes, and then veto could be overturned with 3/5 majority, or President may direct the law to the Constitutional Court for a prior examination before the entry into force. And it is quite an interesting story in this regard, because this whole law we are discussing was proposed, the first draft appeared in the Parliament on 16th December. On 22nd December, the law was passed by the Parliament. It is quite interesting that when the law, that the original draft was different than the law which was later on discussed during in the parliamentary committee, because during the first hearing in the parliamentary committee, additional amendments were added, which changed quite significantly the scope of this law. I'm saying those dates just to give you the speed idea. So 16th, the first proposal. 17th December, some new amendments added during the works in the parliament. On 22nd December, you have the final law. On 23rd December, you have the agreement of Senate. You have a very intensive discussion over the night in the Senate, and around, as far as I remember, 2 or 3 o'clock in the night, the law is adopted by Senate. And I remember that at 7:30 in the morning on 24th December, on Christmas Eve, I've sent a letter to the President, dear Mr. President, please direct this law to the Constitutional Court because it violates all possible rules. And I stated that basically there were negative opinions by the Bar Association, National Council of Judiciary, Helsinki Foundation for Human Rights, other actors. And so the only success was that Mr. President didn't sign the law on 24th December, but on 28th December. So President didn't take advantage of this opportunity to make, because it would, thanks to this, we would avoid this whole discussion whether it would be possible or not to make this law to happen.
Okay.
And moreover, I think the formal right of the President to control the activities of the regards issues which are pretty clear. Here it is the most complicated point of law, and it is not for the president to control those issues. I think that needs to be added with respect to the German situation. Now, with respect to the Article 7, I think the most important thing to get the whole thing going, once that the Council is preoccupied with it, I think then we have the dynamics that brings us to the sanctions. Now, so I think the first step is the crucial one.
Thank you. Yeah, now we have some time for questions from the auditorium, but
no, if we are running
interfere first.
In fact, the question was also. I just wanted to say on the first question that again. A formal right to control, and we should make a distinction between control at the end of a parliamentary process and what has been referred in the question, whether the judgment of a court should be checked by another state organ. And here, a comparative perspective must clearly say that in Germany there's an unconditional duty of all state organs to obey to the decisions of the Federal Constitutional Court, and there would be no way of discussing whether this should be obeyed or not. And this idea of the president being a guardian would require that he effectively is controlling, but you mentioned dates, and perhaps you should be aware that taking the oath of the 5 judges has taken place at 1:30 a.m. So I think this shows that speed is rather more important than perhaps looking at things thoroughly. Thank you.
So speed is rather important. I ask you for concise questions. Please identify yourself. The gentleman on the left here first.
Thank you very much for the really interesting points of views. I'm Michael Meyer-Sender. I work for Democracy Reporting International. We have worked on Poland, also on Hungary, and on many other countries. I have to say it's regrettable to see that the kind of Venice Commission decisions that we knew from east of Poland and east of Hungary now play such a big role inside the European Union, that we have gotten into such a situation. I think the opinion on Poland was excellent, the recent opinion. We see always the same game of trying to puzzling together little pieces from other jurisdictions by disregarding the context of those, and I think you have very finely demystified all these and shown very clearly that they have different meanings in their respective jurisdictions. I think it was a very strong point, Dr. Bodner, that you said this is really about the rules of the game, and I think as a legal profession we should make very, very clear that this is not about right or left. This is really about the rules of the game. Again, Venice Commission has had other constellations where more leftist governments played around with the rule of law and has been clear, and I think we should all support that and make very clear this is about the rule of law independent of political programs. And you mentioned somebody who said, you know, the social program of peace is fine, that's what they were elected for, but not to destroy democratic institutions. My questions, I think we don't have a big disagreement here on the legal finer points. This is, there seems to be a lot of consensus, so maybe I would be interested more in the way forward. What could happen next? And to you, Dr. Bodner, my question would be, could we come in a situation where government does not publish a decision? And I think it's more likely because they've played very hardball. And then courts start not to implement government decisions or to challenge them because they say they're not in line with the Constitutional Court decision. So could we get into a very dysfunctional situation far beyond the Constitutional Court? For the Venice Commission, Professor Grabenberter, I'm interested, you mentioned there may be a compromise. That is very tricky in these situations, of course, because you bring politics into something that we agree is essentially a legal question. So I would be interested to hear more on what options would be there. And Professor von Borg-Dandy, on Article 7, it's true, a majority of the Council could find that there's a serious risk, but then we have unanimity. Orban already said he will not vote for that, paragraph 2. So that could end it, though I think a strong majority of member states saying there's a serious risk is a strong signal. But where are we then with the EU action if it just ends at paragraph 1? Thank you.
I would like to collect 2 more questions. The gentleman with the green sweater here on the left. And then Georg Nolte would be the third.
Okay, Markus Jachtenfuchs from the Hertie School of Governance and a political scientist, not a lawyer. I have a question mainly to Armin von Bogdandy because he raised it, but potentially also to the others. And that is about how strong are the sanctions of the rule of law mechanisms, and the second is, are they really useful? How strong relates to the comparison between the enlargement negotiations. There, the European Union could credibly claim to withhold something extremely valuable, namely membership, for little violations, so to speak. Now, if a country is inside, losing your voting rights, losing EU funds may be a lot, but not very much for a government that is really decided to impose massive costs on its population. So my question is this really enough? But the second question is, would it really be useful? Could it also play the other way, that this even increases the nationalist wave of we are sovereign? Thanks.
Okay, thank you. Professor Nolte? Oh no. I think Georg Nolte was first. So. I'm sorry. Okay, you're earmarked for the next round.
Thank you very much. I agree with the general assessment of the podium that we are really confronting a vital question of constitutional law. My question is relating to the European responses. And I wonder whether the Austrian example is in any way relevant here. And it's a question which is mainly directed to Armin von Bogdandy, who spoke about the fact that this would not be the nuclear option to use Article 7. It's also a question to Christoph Grabenwarter, because if we start Article 7, we have to think about what will be the consequences. I don't want to dismiss it, but I think we should think it through. Thank you.
Okay, I think we start again here with Christoph Grabenwarter.
Thank you. I start with the last point made by Georg Nolte, because it is in fact a crucial issue. One should say, with all differences, the Adressbice finem point should be taken, and that was also in my head when I said a compromise must be found. I'll come back to that in a second. The situation in 1999 was, of course, totally different. There was no Article 7 in place, and there was, and believe it or not, there was not a slight, well, a slight would be too much, but the situation was totally different. There was no danger for the Constitutional Court, not for the media. So I think you could not compare the political thing from the outset, because all you had when this so-called sanctions started, you had a result of elections. You didn't even have a government yet, and no steps taken. So it was just a reaction to a certain result of elections. So the compare what came up very very often to my mind is one parallel thing, is that European criticism paradoxically strengthens government. Also, but that's a political observation, not a legal one. So even more leftish people were suddenly saying, well, it's not only against government, it's against the country. And I can see some and it is confirmed by polls to me that one can again see this here. So this is but that cannot be an argument that Europe must be silent in order to weaken the government, because I think it's not enough. I would like to come back to the question of the way forward. Let's look forward. There are in the political discussion, but Ada Bodner knows much more than I do, but there's the proposal that made by government. One proposal is that by constitutional majority, I suppose, and with the opposition, there should be a reset, and all judges should be newly elected, and a 2/3 majority should be provided for. So, as to the last thing, I fully agree, and it's in the report. So, the German example of having a 2/3 majority for voting is, of course, a very, very good thing. The other part is a very, very bad thing, because you just terminate, and it was the initial proposal I heard was within 60 days, all terms of the existing judges should be terminated, and this again shows an attitude towards constitutional justice which is not a good one. Another example, another proposal which I personally, but I have to say first, we are not talking about the opinion anymore, but as observers and having had, and not in the function of a co-rapporteur in the Venice Commission report, is perhaps, and this proposal stems from Polish politicians in the member of European Parliament, because there will be vacancy of, I think, 3 judges at the Constitutional Court in the next months, including the president, to a commitment by the government so that the 3 so-called December judges, which are already sitting in the court but not taking part in the deliberations, that they are accepted by the court, and as the other side, that the 3 October judges elected by the old majority shall replace the next 3 judges leaving the court. Because the first aim must be to make this court function and to bring it back to a peaceful working atmosphere. And this is not the case at the moment. We had the opportunity to talk to the judges who were sitting, or some of the judges of the constitutional tribunals, and I can only say I do not want to be in such a situation in my future professional life. Thank you.
But in terms of the what's next, I would believe that a non-response or a very tentative or trembling response from the Commission and or a war between the Council and the Commission would be the worst possible outcome, because ultimately any European procedure or the prospect of it disciplines, or at least resets the options of national government. So as soon as the Venice Commission or the European Commission is out of the picture, then all of a sudden the list of possibilities opens up dangerously. And so you have a domestic political back and forth. And I believe that on the one hand, so we cannot afford to treat the migration crisis and the current political deadlock to be totally separate from what's going on with these 2 countries. I mean, the Orban government in Hungary proposed a referendum which asked the people whether they agree to the European Union settling non-citizens in Hungary without parliament's consent. Now, the question is a constitutional nonsense. The likelihood that this will be certified as a referendum question is very high, because there is really nothing in between this question that would stop it from turning into a referendum question, which will thematize a very racist, very xenophobic, anti-migration, anti-refugee discourse, which started in the summer for many, many months to come. So the political discourses are related, and quite a bit of what these governments say in the European political discourses, and also do nationally on the constitutional level, depends on what kind of response they get whether it's pre-Article 7 or Article 7. And so I think we have to be mindful how they are, the political and the legal responses are interrelated. And what we haven't been talking about is that, of course, the debate between the Commission and the Council also relates to the party affiliations of the current governments, both in Parliament and which affects the balance of probabilities in the Council.
Thank you. Adam?
Okay. I would like to follow a little bit about this compromise issue, because I'm really impressed by the understanding of Professor Grabenwatter of all those discussions, including those recent proposals. I think that any proposal, any compromise proposal should not go against the principle from the decision of the Human Rights Committee of the United Nations, Pastuchov against Belarus, which means that you cannot terminate in the middle the term of the judge. And some of those proposals go into this direction, which is basically, in my opinion, unacceptable, because you cannot terminate terms of those existing judges. But I would add one more proposal, which was expressed by the former president of the Constitutional Court and the former ombudsman, Professor Andrzej Zoll, who is, I think, very recognizable by the German audience, because he said that maybe there should be just a technical change of the constitution to increase the number of judges to 18. Because thanks to this, you will be able to assemble those free ones that are waiting to be sworn in by the president, plus those free ones who are right now in the court, who were elected by the parliament, but who were sworn in by the president, but basically they do not have a power to adjudicate cases. So that could be some solution, but basically it is up to the to politicians right now to discuss all those different options. We didn't mention one thing, and I think it is quite important in the context of Venice Commission impact. Because there is one actor who really waited for the opinion of the Venice Commission, which is the United States. John Kerry made an express statement that he's waiting for the statement. There was also a letter for the opinion. There was also a letter signed by 3 senators from both Republicans and Democrats to the Polish government that they are concerned with the situation in Poland. But I think it should be noticeable to the audience that United States is trying to play some role in this situation. What happens next? The Constitutional Court, in this judgment of 9th March, spent some time on explaining the consequences of this judgment, and to a certain extent, the Constitutional Court has predicted that there might be a situation of non-publication of a judgment, especially because we had those discussions before when the Constitutional Court was adjudicating cases relevant to the Constitutional Court in December last year. And the court has made a statement that, and it is also part of the Polish constitutional law, that judgment, even if it is not published, is binding for the Constitutional Court itself, as well as for other actors that may follow it, even despite the publication of a judgment. So what does it mean? It means that the Constitutional Court, even without a publication, will be able to use the rules from the old law, so from the law of 25th June 2015, so all those rules of procedure. So it may go forward with those cases that are waiting in a queue to be, as regards being adjudicated. Second, if you have any regular court who is looking at the jurisprudence of the court, even if those judgments are not published, the common courts, by virtue of the Polish constitution, can use the constitution directly. So the courts have the opportunity to say that, okay, so will not use this particular provision of statutory law because it was declared by the Constitutional Court. And even if the judgment was not published, the court has already such a possibility. But in practice, it may create, in fact, a legal chaos, because you will have a number of individual interpretations made by courts, and you will have the whole administration which will say, we cannot accept those judgments because they were issued disrespectfully of the procedure, because there would be some indication by the government, if the government goes hardball, as you said, that you shouldn't treat those judgments seriously because they were not made in accordance with a proper procedure. But I'm positive about publication of a judgment. I still believe that there is a chance for publication, that the judgment will be ultimately published. Today, interestingly, there was a result of the poll, and according to the recent poll, 75% of the Polish citizens claims that the government should publish the judgment, which is quite a high number when you compare this poll to some other polls concerning this dispute.
Thank you.
So, to answer your question, so first of all, the rule of law mechanism in itself has no formal sanction. So whatever force it eventually has depends on the Article 7 mechanism. Now, is it possible to imagine that it goes the entire way through? So we have the starting of the procedure that is possible. Can it go the whole way through? It has been, to my mind, very intelligent by the Commission to call it the rule of law framework and not the Article 2 framework. So it's not on democracy and human rights and all these other wonderful things, it's the rule of law. Why stressing that element? It's stressing that element that if the European Union has an identity, and if the European Union has a narrative, and if the European Union has something on which all they come together, it's the rule of law. It's the oldest image that you have had. It's a community of law. That's the very heart of the European Union. And for that reason, and that is what is at stake here, disobeying the Constitutional Court. You cannot imagine anything stronger than disobeying the Constitutional Court for defying the very heart of what the Union stands for. For that reason, I think there's good grounds that even the Hungarian government in its current form will obey. The Hungarian government has been protected by the popular parties several times. It owes something to them. But if there is something in the popular party, European Popular Party, it is the rule of law. But for that very reason, I think at the end it is possible to convince the Poles that the government is convinced how central that element is to being part of Europe. And if that doesn't work, it might add to all these other elements that really put the European Union into peril. But to have a European Union where you have a country that defies the rule of law at that point, that is a country where the euro is not working anymore. It really brings us to another situation. And I think when looking into that abyss, people become reasonable.
Thank you. Time is up, and what we take from this panel certainly is that we are in the midst of a very dynamic process, which brings to the fore again the very old questions of the constitutionalist tradition, but also challenges us in new and unprecedented ways. And I'm sure we will all be challenged also and provoked to follow up on this process. You will have plenty of opportunity to comment further on Verfassungsblog or to interact through social media. I understand that we have already online the initial position and statement of Renata Uitz, and maybe we will have more input from the speakers to follow, but also comments and contributions by you here from the audience, but also from members of our virtual audience that has been following this discussion today on Verfassungsblock. I would like to invite you now to join me in thanking our speakers. Thank you very much for a very interesting and thought-provoking discussion tonight.